big poppin'. Money in the bank coming, dropping a deposit. Having it my way, so I got these bitches watching. Steady getting to it, couldn't fit it in my pocket. Flexing everything, baby, tell me big poppin'. Money in the bank coming, dropping a deposit. Having it my way, so I got these bitches watching. Steady getting to it, couldn't fit it in my pocket. Flexing everything, baby, tell me what the topic.
What's poppin', everybody? Welcome back to the bar. To the bar. What's poppin', everybody? Welcome back to the bar. It's your favorite goss and doctender, that girl Henny, and I'm here to pour up your hot shots of docs and goss. And tonight, we're going to be completing something that I started a few months ago, where I was out there in New York at the Diddy trial, and I was covering it live and direct for y'all. Now, unfortunately, I will not be in Nueva York to cover the conclusion of the Diddy trial where he gets sentenced. However, I will be keeping up with it tomorrow, so we will be live tomorrow morning covering the Diddy trial for you. Now, shout out to everybody who's joining from the multiple platforms. Shout out to everybody who's on Twitch and who is on YouTube. And if you are here on YouTube, then you know how this goes at some particular point in time, which will probably be after we cover some of this Diddy stuff. We're going to be switching over to the Twitch. The mod will drop a link. I will then pin it at the top of the screen, and that will begin the countdown to when we leave Twitch. Now, you don't have to leave whatever platform you're on right now. I do prefer everybody to be over on YouTube for right this moment, and then we can head over to Twitch when the time comes. Right now, the reason why I wanted to come and talk about Diddy is not just because I covered it and I feel like I have to close the circle, so to speak, which, by the way, I really don't believe that we're closing a circle, because if Diddy doesn't come home, which I don't think he's coming home tomorrow, if he doesn't come home tomorrow, you can best believe, based off of past behaviors, Diddy is not going to take that no. Okay, and we're going to get into Diddy and his taking of the no's and not wanting to take the no's and all of that stuff in just a minute. But if you are new here, if you catch this on the replay, welcome to the bar. Please be sure to like, comment, and of course, subscribe. Click the notification bell, select all so that you get notified whenever I do a video. And if you're a returning Mob Down Hidden Game member, y'all, what's poppin', y'all? All right, so it's been a lot that has gone on. Yesterday, I covered some of what the government was looking for. I didn't really get into the history of the case and all of that stuff with you guys, but I felt like I did a disservice to y'all by not covering the history of the case, because you guys weren't in there and it was so long ago. And people are still out here spinning the defense's narratives, which, by the way, anybody that is sitting here looking and saying, well, the defense is saying this and the prosecution is saying that, you must not have watched court trials, because at the end of the day, it's always going to be a difference of opinion and a different story that gets told. Of course, the defense is going to say that people lied. Of course, the defense is going to try to poke holes in the prosecution's stories. But what's most important here is I want to make it very, very clear that I am not here for the government, okay? I am here for what I heard in the courtroom, and I use my own thinking, and I don't go with the crowd, and I don't use a herd mentality. I use my own critical thinking skills to watch and observe everything that I saw. Now, one of the things that I did come to the conclusion of was I do need to read to you guys what happened in the court according to the government, because all you're really hearing is the defense right now. The defense has been very, very loud about this case. They've been very, very loud with their narratives, while the government has not really said much in these past 3 months. But in the past 3 months, we've heard more from the defense team than we have anybody else. And I want to talk about that for a second, because as someone who was sitting in the courtroom and observing a lot of things, one of the themes that I kept hearing, and the reason why I say themes is because when you hear something and it becomes a pattern in something, it becomes a theme, right? So one of the themes that I kept hearing was, you can't tell Diddy no. Diddy doesn't take no for an answer, right? Right. And in sitting back and looking at all of the court documents that I have pulled, that I have read, whether I covered them or not, there's been a lot of documents from the defense. And if we take it all the way back to when Diddy first got arrested, the minute that he was arrested, you thought it was on Friday. What's today? Oh, it's on Friday. Okay, so I did have a day, but that's okay. I'm sorry. Thank you for correcting me. I'm a day ahead. Okay, I'm a day ahead. Sorry. I'm a day ahead. It is on Friday. Duh. I'm thinking today is Thursday, honey. I'm trying to rush the week. So When he first got arrested, what's the first thing that he did? He went for bail. And what happened? He got denied. He got denied not once, not twice, but I think he got denied bail 3 times. I'm not really 1,000 on that, but he kept going for bail. After his sentencing, he went for bail again. After the bail didn't work, what did he go for? He moved for an acquittal or for a new trial. And at the 11th hour, the judge came in and the judge said, okay, enough of this bullshit. And the judge denied Diddy's request for an acquittal or for a new trial. Now, let me go ahead and let me pull this court document up for y'all. I know that you guys may have already heard this from other people, but you did not hear it from me. So, of course, I have to give you my 1-2, or else we don't have a complete story over here, right? Right. 1 second. Guidelines, those are all of that. Did we get the denial in? I could have swore we had the denial in. Oh, wait, let me go to my regular inbox and not just that inbox. Okay, so pull that up for y'all. We got the document. We got the content and the documents. Shout out to everybody who is in here. Appreciate y'all. Make sure that y'all are liking and sharing. Share it up, share it out. Okay, even if you're sharing it to yourself, share it to your text messages 50 million times. But whatever you do, just make sure that you're sharing it out so that you let YouTube know, like, hey, we like what's going on over here and we'd like to keep it going. That's not it. That's not it. Nope. Denied right there. Bang. All right. So up on your screen right now, what you see is you do see the denial letter. And why is my music not playing? I don't like that. Okay, there we go. All right, let me go ahead and let me big this for y'all and get into a little 1-2 of everything. Okay, so as I stated, we already know that his bail was denied. So this is the denial letter from Judge Arun Subramanian. Okay, and basically, if you don't remember what happened when Diddy was applying for this acquittal or for a new trial, he cited multiple different reasons why he should be given this acquittal. So the judge has finally given his 1-2 on it. Can you guys see that? Can you guys see that good? Let me see if I make it. Okay, maybe that's better. Are they cutting up over there? No, I don't. I can see them. You could actually see them on the screen uniquely. On the screen, you see everybody. Nah, I think we good over there for right now. I don't see anything happening. Okay, so Judge Arun Subramanian opens up his case and his response. Hey, Mama Flip. It's been a while. Good to see you. It has been a while. I have to call you. It's been a while. It's been a while. Okay, so he says after an 8-week trial, a jury convicted Sean Combs of 2 counts of transporting people for prostitution under the Mann Act. Before the government rested its case, Combs moved for acquittal under Rule 29. The court reserved its decision under Rule 29B, and Combs renewed his motion after the verdict. He also moved for a new trial under Rule 33. For the following reasons, both motions are denied, right? So it goes on to say that the government first indicted Combs on September 2024 for violations of the Mann Act, for sex trafficking, and for racketeering conspiracy. In its third and final indictment, the government's case was built on Combs's actions beginning in 2004 and continuing over the next 2 decades. The government alleged that Combs arranged for and paid men to travel across the United States and internationally to have sex with Combs's girlfriends, Cassie Ventura and Jane. Further, the government alleged that Combs transported Ventura and Jane to have sex with those men, gave them illegal drugs, and physically abused them. This, the government argued, was all the product of the Combs enterprise, a criminal organization comprised of Combs, his business, and his employees. On the government's telling, the organization existed for lots of reasons, not only to run a global business in media, entertainment, and lifestyle industries, but also to fulfill the personal desires of the media, entertainment, and lifestyle industries, but also to fulfill the personal desires of Combs, particularly those related to Combs's sexual gratification. The case went to trial. After the government rested, Combs moved for acquittal. That motion focused mostly on racketeering and sex trafficking, but also contested the Mann Act charges. With respect to the Mann Act, Combs argued that the escorts who testified didn't travel across state lines, that they disavowed that they were paid for smex or engaged in prostitution, and that they sometimes were paid even when they didn't have smex. The court withheld its decision and the charges went to the jury. The jury agreed with Combs about the smex trafficking and racketeering charges, acquitting him of both, but it disagreed with Combs about the Mann Act, finding him guilty. Okay? Combs now renews his Rule 29 motion and also moves for a new trial under Rule 33. Now, pause for a second. If you remember, when the trial was going on, I told you that he had put in for this Rule 29 motion for an acquittal during the course of the case. He had did this before everything was over. The judge reserved the right to come back to the Rule 29 after the verdict. And because that it was focused mostly on the sex trafficking and racketeering, this is why we didn't get an answer, right? So now he reapplied and he's asking for it under Rule 33 for a new trial. Now, the judge goes on to say that the defendant's motion, on the defendant's motion, a court must enter a judgment of acquittal of any offense for which the evidence is insufficient to sustain a conviction. Evidence is sufficient to sustain a conviction only if it is non-existent or so meager that no responsible jury could find guilt beyond a reasonable doubt. Now, clearly, the jury did not find guilt beyond a reasonable doubt because they did find him guilty of the Mann Act charges. Okay, so that's not going to stand. All right. So, as the Second Circuit has explained, a defendant challenging the sufficiency of the evidence bears a heavy burden because the renewing court is required to draw all permissible inferences in favor of the government and resolve all issues of credibility in favor of the jury verdict. So that means that even though he's coming with this, he had the heavy burden of proving his case, proving that the government fudged up. They didn't have the proper evidence in line, and it wasn't going to work in his favor. I can just tell you that right now. But anyway, under Federal Rule of Criminal Procedure 33, upon the defendant's motion, the court may vacate any judgment and grant a new trial if the interest of justice so requires. Generally, the trial court has broader discretion to grant a new trial under Rule 33 than to grant a motion for acquittal under Rule 29. But it nonetheless must exercise the Rule 33 authority sparingly and in the most extraordinary circumstances. So basically, he has to have extraordinary circumstances. There must be a really good reason for him to have a good trial, another trial, aside from the fact of, I don't like the way that the verdict came out because it didn't turn out in my favor. And that's basically, to me, what this was all about. Okay, so now let's skip on down here to the discussion. Okay, so Combs makes two types of arguments under Rule 29, legal ones about the correct definition of prostitution and factual ones about the evidence at trial. On Rule 33, he argues that the evidence on the acquitted counts prejudiced the jury on the counts of conviction. So he's saying, because y'all brought this into play, because y'all were trying me for RICO and sex trafficking, it prejudiced the jury to be able to find me guilty of Mann Act charges. He's saying that there was basically no evidence that proved that. And that is a total bold-faced lie because the evidence was right there in our face. Okay. So, Rule 29 legal arguments. The legal arguments in Combs' Rule 29 motion turn on what the word prostitution means in the Mann Act. The Act has two clauses. Both share the same Act element, transporting somebody in interstate or foreign commerce, but they have different intent requirements. The first clause, the one at issue here, requires that the defendant intend intended that the transported person engage in prostitution. The second clause, a broader catch-all, requires that the defendant intended for the transported person to engage in any sexual activity for which any person can be charged with a criminal offense. Together, they read, whoever knowingly transports any individual in interstate or foreign commerce or in any territory or possession of the United States with the intent that such individual engage in prostitution or in any sexual activity for which any person can be charged with a criminal offense. And that happened here. So they summed it up right here for us, but that did happen here. Okay, so at trial, Combs proposed that the jury instructions define prostitution as engaging in sexual activity for money or its equivalent. Okay, citing Black's Law Dictionary and state law definition. So this is where he's been in his books, reading up on his case, to slide notes to his attorneys, and to be active in his case. He's been going to the Black's Law Dictionary. Okay. The court adopted Combs's definition in its instructions to the jury, which proceeded to convict Combs under the definition. So he came up with the definition by using the Black's Law Dictionary, which it says that prostitution is engaging in sexual activity for money or its equivalent. And so the jury still found him guilty with his own definition. But now here we are with him arguing the definition of prostitution. Okay, now he argues that his proposed definition was wrong all along. Prostitution, he says, instead requires either that the defendant have a commercial motive, that the buyer has sex with the seller, or both. That would mean that there was never any prostitution involving Combs, who lacked a financial motive and didn't directly have sex with any of the men he hired. On his telling, applying a broader definition would create constitutional problems. These arguments didn't hold water for the reasons below. Let me tell you something. Remember I told y'all, Henny glasses in the chat. Chat, if you remember me saying this to you, throw them Henny glasses. I said he was going to press his luck with this judge. And it sounds to me, based off of the way that he is responding, it also sounds to me based off of the way that the last court date went, Judge Submarinian may just be at that breaking point with Diddy. Hold on, let me get my water jug. Hold on 1 second, y'all. You come in, let me get the water. Let me get my water. Don't leave. Stay your butts right there because we just started. Where is my water? Hold on 1 second, guys. Y'all gonna take the garbage out. Okay. I'm back. Did you miss me? Did you miss me? I'm back. Okay. So now, where were we? Okay, I was saying, I think the judge has already reached that breaking point. Now, Mama Flip, if you are still in here, please let me know you're still in here. I have a question for you. All right, so can you take the garbage out? Okay, so Combs didn't forfeit or waive these challenges, all right? The first question is whether Combs can bring a legal challenge to his conviction under Rule 29 motion. The government contends that Combs should have made his challenges earlier under Rule 12, and so he forfeited them, and that the instructions given to the jury on the definition of prostitution was of his own devising, and so he waived any claim of error. Neither argument persuades the court, though. So he said, look, neither one of your arguments are persuading me. This is what I'm going to say. Oh, you are here? Okay, you're going on Friday, right? Call me after. I'll call you after the live. I'll call you after the live. So it says that, so basically, the government is saying that you brought this definition of prostitution to the table. And because you're the one that brought the definition to the table, you can't now come back and say that the definition is incorrect. And so the judge is saying, I'm not impressed by either one of y'all. Because first, Combs can bring his legal challenge under Rule 29 despite not raising them earlier. These challenges are routinely made and decided by courts in this circuit, including the Second Circuit itself. Second, Combs didn't waive his arguments concerning the definition of prostitution by proposing the instruction the court gave. To be sure, this case involves an unusual series of events. Combs proposed that the instruction the court adopted it, and now Combs says that it was wrong the whole time. Thank you for the super chat, Mama Flip. Okay. Ordinarily, the invited error doctrine would bar this kind of challenge to the instructions. So basically what he's saying is ordinarily, this isn't an ordinary case, and ordinarily it would be barred. But because this is not an ordinary case, it's not barred, okay? But Combs argues that his Rule 29 motion doesn't challenge the jury's instructions, but instead turns on what the definition of prostitution should be. What it should be. So he's not necessarily saying that the definition is wrong, but he's saying this is what it should be. Keep it real with Don K says, I said last week, I think judge is going to give him 3 to 5 in custody because prostitution wants 11 years. Now he has letters written from victims, so he's going to get in the middle of 3 to 5. I agree with you. I believe it's going to be maybe 3 or 5 years. I'm leaning more towards the 5. And I'll explain why I'm leaning towards the 5 in a minute. But thank you for stopping in and keeping it real with Dom K. So on that view, the jury instructions aren't relevant to his argument. Combs is right, okay? And they're saying they cite Mashudo versus United States. The Supreme Court held that a reviewing court's limited determination of sufficiency review does not rest on how the jury was instructed, though that holding addressed only whether the due process clause requires that an appeal court abide by erroneous jury instructions given below that advantaged a defendant. Okay. And then he's continuing to cite case law. So hold on one second. In United States versus Blazak, it held that this principle also adapted when the jury instructions disadvantaged the defendant, vacated on other grounds. There, like here, the defendant failed to object to the jury instructions, but then challenged the evidence based on a different interpretation under Rule 29, relying on Mashido, I think that's how you say it, in the second court that held in answering that question. All right. The court did find the defendant's Rule 33 challenge to those instructions forfeited. But Combs isn't making that kind of an argument here. These cases support Combs's contention that the actual jury instructions aren't relevant to his Rule 29 challenge. So he isn't barred from now arguing that Mann Act means something different. So basically, he's not barred from making this the way this challenge, the way that the government is saying that he's barred from making the challenge. You understand? So he could challenge this all he wants to. All right. Combs' newly proposed definition of prostitution is wrong. This is what the judge is saying. We're reading Judge Arun Submarinian's response to Diddy's request for acquittal or a new trial. Okay? Combs argues that prostitution, properly defined, has 2 elements absent from this case. First, the defendant must have a financial motive. Second, the exchange of money for smecks must be bilateral. Whoever pays for the smecks must engage in it. Both arguments share a similar structure. Each poses that the definition of prostitution at the time of the Mann Act's passage was abroad in some respect. Then each suggests a new way to narrow the definition to avoid potential constitutional problems. If Combs is right, then his conviction, even on the alternative theory, like aiding and abetting, should be revised because no prostitution occurred at all. But both arguments fail Okay. The judge said, okay, but this argument fails. Combs got it right the first time. The correct definition of prostitution in the Mann Act is smex in exchange for money or its equivalent. And that definition poses no constitutional problem. So look at that. Your own definition helped convict you, sir. One, prostitution means smex for sale. To any modern reader, the plain meaning of prostitution is smex for sale. Every modern dictionary the court consulted says the same thing. Prostitution from the Oxford, from the Merriam-Webster. They all say from prostitution from the Black's Law Dictionary, the 12th edition, 2024. Okay, it says the practice or an instance of engaging in sexual activity for money or its equivalent, commercialized. The Mann Act's history doesn't suggest that a different definition applies. True, in 1917, the Supreme Court indicated that prostitution as used in the statute could be for hire or without hire. And that appears to reflect how the word was used at the time. Black's Law defining prostitution as common lewdness, whoredom, but the court walked away from that expansive definition 3 decades later. Okay, in Cleveland versus the United States, recognizing that prostitution normally suggests sexual relations for hire. And while Cleveland didn't explicitly overturn their decision, ow! You just scratched the hell out of me. Hi. I'm sorry, y'all. It's Milo. Where were we? The definition of prostitution was key to its reasoning. All right. So, in 1986, Congress amended the Mann Act, cementing the common sense definition of prostitution. It struck the entirety and reenacted it, reinserting the prostitution clause, but cutting the laws. Okay, so like the debauchery and immoral purpose. Now, they could have left the debauchery and immoral purpose in there because at the end of the day, it is debauchery and immoral purpose that is still in there, right? Okay, so they're arguing about the prostitution, and basically in the end, the judge says, but Combs isn't satisfied with that definition. He says that prostitution has 2 additional requirements, neither of which is grounded in the text of the statute. The meaning of prostitution at the time of the Mann Act's enactment in 1910, or its meaning when the statute was amended in 1986. For the following reasons, the courts rejected Combs's proposed additional requirements. So that gets rejected, okay? The defendant need not have financial motive, because this is something that a lot of people have been saying that, oh, there had to be a financial motive for him. He had to be the one to have sex with them. Now, I'm going to say this to y'all, and I don't give a damn who gets mad at me when I say it. What Diddy is proposing to the court is what people were saying outside of that courthouse after the trial was over. And the fact that YouTubers were saying it first and then the defense went in action with this is telling me that either he's watching people or people are talking to people behind the scenes and they ain't saying it. And I don't give a damn who don't like it. As a matter of fact, I'll be in New York during the month of November for Thanksgiving. So if anyone has an issue or wants to come holler at your girl, hit me up on IG and let me know, and I'll meet you right there in Foley Square, period. Okay? Now, Combs first argues that prostitution in the Mann Act required that a defendant have a financial motive. There's nothing in the text of the statute to support this requirement, and it doesn't make any sense in this context. Combs wasn't convicted of prostitution, but rather transporting others for prostitution. This is where they get it all misconstrued and all chopped up, because it's, oh, this is a prostitution charge. This is for prostitution. It's prostitution, guys. He's locked up for buying a little coochie or a little pussy every now and again. But that's not what he's actually locked up for. He's locked up for transporting others to engage in prostitution. That's the Mann Act. Duh. Duh. It ain't about the selling of somebody's box or the selling of somebody's meat box, meat pole, sausage, of somebody's sausage. It's about moving people around like pieces on a chessboard in order for them to engage in prostitution. Period. And I'm going to read that part again for the slow ones that are going to come on the end. And they're going to be, Combs wasn't convicted of prostitution, but rather wasn't convicted of prostitution, but rather transporting others for prostitution. Combs seems to be conflating two things: the definition of prostitution and the motive of the defendant who transports somebody for prostitution. The statute requires only the intent that the transported person engage in prostitution. Combs' argument imposes an additional mental state required for the transporter and grasp into the word prostitution, a word that by itself doesn't contemplate anybody but the parties involved in this next act. What happened in this case was transportation for prostitution, even under Combs's definition, even under Combs's understanding of the term. Combs transported the escorts who were financially motivated, I said this, and intended for them to engage in prostitution. Whether Combs himself was financially motivated, neither enters the calculus. There's no base to adopt Combs's proposed financial motive requirement for defendants in the Mann Act cases. I said all of this. I should have went to school and maybe I'd be a little better than what I am. But you see, when I said this, I got hated on. Ciao, boo, bye, and good night. Now, the next one is a bilateral exchange of money for SMEX is not required. So Combs also argues that prostitution is a strictly bilateral transaction. One party pays the other for SMEX, then those same two parties have SMEX. That definition would narrow prostitution almost out of existence. It would exclude any situation in which a person pays a third party, like a brothel, to have SMEX with an employee. To support that narrow construction, Combs invokes a series of state court decisions that he says adopted his definition, putting aside that none of these decisions interpreted the Mann Act, as the government points out. These cases aren't good evidence for the meaning of the word prostitution. To the extent that these cases are relevant, they stand only for the proposition that states have defined prostitution differently within their statute. Basically, all it did was prove that each state has come up with their own kind of statute for what prostitution is. And he goes on to say that the cases can be grouped into two general categories. And the first group is the masturbation cases. And each of them... Did I read this? Mama Flip says, yes, at that girl hitting defense, throwing everything and kitchen sink included all excuses from supporters inside, outside, and on social media. They use the Black community and their women blaming tactics. Now, I have to say, yes, ma'am, because the hating that has been going on, especially now that the case is coming back around, the hate that is spewing, the venom that is spewing. Even when we get to this defense's last letter to, because Mia wants to talk in court, y'all. So we're going to get to this. We're going to get through this a little bit. I'm going to read a little bit more because we're learning something here. We're learning that while the narrative has been that Diddy was charged with prostitution, we're actually learning that he, in fact, was not charged for prostitution. And it's not a prostitution charge. The way that TMZ and everybody else has been saying, it's not a prostitution charge. It is, in fact, transportation to engage in prostitution. And it is completely different from the definition of prostitution. So now let's get back to what I was just reading, because y'all know I laugh at inappropriate things and things that make me a little uneasy or catch me off guard. So the cases can be grouped into two generalized categories. The first group is the masturbation cases. In each of these, a defendant must either masturbate in front of someone else for money or offer to. Have any of you been offered any monetary gain or its equivalent for you to self-pleasure in front of some? Shut up, don't answer that. Okay, don't answer that. Don't answer that. In each of the defendants, in each case that he proposed, the defendants was charged with violating the state's prostitution statute. Each of those statutes defined prostitution in a way that the court interpreted it to require sexual contact between two people involved. Oh my God, y'all are answering it. Abuse is swag is love language. Oh Lord. Okay. Combs argues that these cases show that prostitution requires a bilateral exchange of money for sex. Not so. These cases involve the question of whether there's prostitution when there's no sexual contact at all between the participants. That isn't the issue here, given that there's no question that Ventura, Jane, and the escorts had sex. So, what the judge is saying is the cases that Diddy's lawyers tried to use, they were saying, okay, this involves no contact between anyone. There's goods exchange, but you're not touching anybody. So if you give me 5 bands and you want to see me, bands will make her dance and get it popping with myself, and you not touching me, then this definition would apply. But the fact is, even though he was the one that was touching himself and he wasn't engaging with the escort, there was still sexual contact that happened because it went down between Jane, Cassie, and the escorts. So he can't use those. All right. The cases didn't address whether prostitution requires a bilateral exchange of money and sex between only those participants, as Combs insists. And even if they were relevant, these cases didn't turn on a bare word prostitution, but instead on the definitions provided for each statute. So the definitions, they have nothing to do with that. Now let's see. The second group of cases concerns strip clubs and commercial voyeurism. Right? A few of these cases simply aren't relevant. One did nothing but note that some forms of commercial voyeurism are distinct from prostitution. In another, a court held that a dancer didn't engage in prostitution with the patron who touched the clothing covering her genitals because Missouri law required touching the genitals themselves. Okay, so let me find out who lives in Missouri. Because y'all out there in Missouri touching on the woo-ha. Well, I can't say it's just in Missouri, but I mean, they're talking about it in the case, though. Okay, but again, recall that Combs's proposed definition of prostitution turns on whether the money and sex flow between the same people, not whether sexual touching happened at all. And notably in Burgess, which is one of the cases they cited, the statute didn't require a bilateral exchange of sex and money. It covers statutes where something of value is received by the person or by a third person. Okay, 2 other cases in this category appear more relevant on first blush, which is the State versus Taylor and Wooten versus Superior Court. Courts in Arizona and California. And in these cases, they said in Arizona that the court held that the charged employee who engaged in the touching with another dancer was legitimately prosecuted under Arizona's prostitution statute, which required sexual conduct with another person. That was so even though the defendant didn't pay the other dancer, undermining Combs's proposed construction. So this case didn't even touch what we're talking about. So he said next, Wooten, the California court held that the purveyors of similar purveyors, I get whatever that word, club weren't involved in the prostitution, okay, and that a combination of statutory definition of prostitution and prior case law led to the conclusion that California statute was not written sufficiently broadly to encompass a sexual transaction for a customer who engages only in voyeurism. All right, so now let's get down here because finally people are through. Okay, First Amendment protection while a brothel does. Okay. They're still defining prostitution and sex, and basically that was all. Okay, so he says, okay, he goes into vagueness, and they talk about a lot of case laws here, substantive due process, federalism. These are all the things. The First Amendment. I wanted to read this First Amendment because this caused a big hoopla on the net. Now, Diddy is arguing that because he's an amateur pornographer and consumer of pornography, his conviction violates his First Amendment right. And that argument fails for two reasons. First, Combs' conduct is not protected by First Amendment. First Amendment protection applies only to conduct that is inherently expressed. Conduct is inherently expressive if there's both an intent to convey a particularized message and the likelihood was great that the message would be understood by those who viewed it. Through film, although film is an expressive medium protected by the First Amendment, at some point it must certainly be true that otherwise illegal conduct is not made illegal by being filmed. So in other words, just because you're filming it and you want to call yourself an amateur pornographer and a connoisseur of porn, that doesn't mean that you're protected under the First Amendment right, okay? So it says, and the same goes for the desire to view pornography performances. At some point, illegal activity can't be laundered into constitutionally protected activity just by the desire to watch. Combs' conduct goes far beyond that point. Evidence at trial showed that when Combs filmed, he didn't particularly give notice ahead of time or ask for consent as a film producer would, and that he masturbated, suggesting that the purpose was his immediate sexual gratification. So basically, Diddy filmed people, didn't get their consent. They didn't even know they were being filmed half the time. And I think the part that the judges were talking about is these videos were also used as blackmail material later on against Cassie and Jane, allegedly. Okay. Now, second, even if Combs' conduct falls under the First Amendment's protection, his conviction doesn't violate it. If speech is implicated, then the Mann Act is the content neutral restriction that has an incidental effect on speech. Such restrictions are analyzed under the O'Brien test, okay? Combs challenges only the second prong, whether the law furthers an important or substantial government interest. At the outset, the government has a strong interest in controlling prostitution, within its jurisdiction, okay? And then they go into there's no question circulating prostitution, given the circumstances. Again, add to that the significant federal interest in halting the interstate sex trade, which may be associated with all matters of other criminal conduct. Contrary to Combs' assertion, his own activities implicated many of these concerns. While paying for sex he enabled commercial prostitution, distributed illegal drugs, and was physically violent. Against that, Combs argues that the government's proper interest in controlling prostitution is not implicated and is under in this unprecedented case because there are no minors involved. All right. So it says also, finally, though Combs doesn't mention the foregoing of O'Brien, the court notes that the Mann Act is broader than necessary and the requirement of narrow tailoring is satisfied so long as the regulation promotes a substantial governmental interest. All right. Combs is right. The Mann Act's text and application have changed over the last century, but it has little relevance to his conduct, which still, at the heartland of it, the act's legitimate proscriptions. Unsurprisingly, then his conviction raises no constitutional problem. So basically, the judge says there is no constitutional violations or any of that, and he says that the court's just not having it. Okay, so the conclusion is, for all these reasons, that his Rule 29 and 33 have been denied. Now, let me just say this to you guys before I continue on to say some things. Now, what I found very disturbing throughout all of this is the fact that there was never a rest. Okay, it was never a rest. We got to see exactly what everyone was saying about the "you can't tell Diddy no" playing out right before our eyes every day of this trial. Okay, let me tell you how. Let me sip my water and let's get into it. Now, his controlling nature was very much on display in the courtroom. Remember, I was on the 24th floor and I was there in the overflow. While I couldn't see the jury every single day, what I could see was Diddy. What I could see was the person on the stand. What I could see were the attorneys, all of them. And when Diddy didn't like something, Diddy would shift in his seat. Diddy would pout. He would scrawl his face up and he would tap. It would be this tapping on his leg. If there was something that was said or something that he wanted said or something that he didn't like, he passed a note to his attorneys. He was very much active and participating in his defense. And I'm not saying that it's just the fact that he was participating in his defense that shows that there is a controlling nature. It's the demeanor of everything. Now, anybody else that's sitting up there that was on the 24th floor may not have been paying attention to all of that, but I was paying attention to everything. I was paying attention to when Diddy was pushed all the way back from the table, and the attorneys were sitting up on the table, so he's sitting kind of back from them. I was there. Remember, I told you how when Brian Steele came up to bat, said he can go and question Mia, Diddy sat up on the table like he was getting ready to watch a show. And anytime there was a point that he wanted made, he passed the note. So he was very much in control of what was going on. You knew when he wasn't happy with one of his lawyers because it showed in his body language and on his face. The fact that every time the court turned him down for something, and he came back with something else, that shows you that he does not take no, and that everything is always negotiable. As a businessman, he is always negotiating, and this case was no different. Diddy was still trying. He's still trying to this day to negotiate. And the fact that people are not looking at the behaviors that were described to us by Cassie, by Mia, by George Kaplan, by Capricorn Clark, by George Lopez, by everybody who worked for him and everybody who had been around him that was brave enough and bold enough to come and take the stand. If you weren't paying attention to what they were telling you, then you aren't going to pick up on what's being displayed right in front of your face. The fact that Diddy wants to say something at his sentencing hearing, and he wants to do it in designer clothes. He wants his clothes so he can address the court. You know why? Because this is the stage for him. He's putting on a performance. This is his way to finally get a say. Because the whole time throughout this trial, Diddy only said a couple of words. And that was when the judge addressed him at the end. But you have to think about this. There's going to be YouTubers, there's going to be new media and legacy media in there. There's even going to be people who are just there to spectate. They're going to show up to that court to hear what's going to be said. There's going to be sketch artists that are in there, and he wants to make sure that his right angle is captured. That he wants to be able to say what he needs to say to persuade everyone. Because even now, Diddy is still telling his lawyers what to say. Do you really think that was that press run that his lawyers went on, that Alexandra Shapiro went on, that Nicole Westmoreland went on, and that Mark Agnifilo was on doing those interviews? Do you think those were their idea? Hell no. That was his idea. Because he needed somebody to come out there and be a buffer. Somebody to come out there and push the narratives harder. And I'm sorry, guys. I do believe that there are some people that were paid under the table to push some of these narratives so that he can influence the court of public opinion. Because if he's asking for a new trial, that would have meant a new jury. And a new jury meant a new set of people. And a new set of people needed to be influenced with the narratives that he needed pushed out of there. So let's blame the victims. Let's say they all lied. Let's say that none of this was ever happening. The fact that his lawyers came with this argument that he and Cassie's relationship was a great modern day love story and that their text messages brought him to tears, he romanticized abuse, taking the blame off of, making it poetic and seem like there was nothing that was going on. But there were bruises. There's scars that she's left with. There was a gash over her head. That's a modern day love story. And while people talk about statutes of limitations being over on somebody's case, clearly they're not. Clearly there's something that links them all together. And you want to know what links them all together that everybody forgets? While Gina did not come into the courtroom and testify, Gina did do a grand jury testimony. And that grand jury testimony that adds that extra link to the chain is what connects everything together, whether she testified in trial or not. And remember that there's evidence that the judge knows, that the prosecution knows, that the defense knows, that we will never know that was presented. There's stuff that was kept out of this court case that we did not get to see. And the judge is privy to all of that information. Let's not forget that yesterday I read in the government sentencing suggestion that Diddy was lying to those therapists. He had not told them everything that had gone on in the cases. And remember that those therapists said that they could not confidently say that Diddy would not offend again, be it violently or be it sexually, that he would not violate, they couldn't guarantee it. And these are the therapists that he brought in. Because remember, they said that these were their private therapists that they brought in. Which shows you that he has been controlling and manipulating the situation behind the scenes. They wanted Dr. Dawn Hughes' testimony taken out. Because if people paid attention to Dr. Dawn Hughes' testimony, then they would have realized that there were psychological effects that were happening in front of our eyes while that trial was happening. And to all of those people that say that Diddy has changed, oh, look, the government even said that he completed programs. When you have decades of that type of darkness inside of you, that type of power and control, where people are dispensable, where you've gotten away with treating people like they were beneath you and that they were scum beneath the scum beneath the scum beneath your foot. You don't just change. Listen to what he said, that outside of his program, Free Game, that there were no other educational programs in the NBC. When that in fact was a lie. His mental state is totally on display for all to see. Have people done some things that were questionable in this trial while they were telling their stories? Yes. But I'm quite sure if you sit down with any person who's been through DV, you'll see that it's not black and white. Anybody that's been in any kind of abusive relationship, they're not black and white situations where you could just explain them away in a logical manner where people are going to understand. Because unless you've actually been through that, you'll never understand what it's like to live through that. You'll never understand the mentality of someone who's being abused because you'll never understand the psychological warfare that goes on. See, physical abuse starts in the mind before it's ever physical. And once a person has control of your mind, they pretty much have control of you. And how does a person get control of you? Through gaslighting, through love bombing. And when you're a rich multi-millionaire, you can sway anybody. If you look at the lives of all of these people, if you remember the stories, if you didn't watch the videos of the victims' impact statements that I read, everyone was in their 20s and he was in his mid-30s, giving him a 15 to 16 year advance over all of them. He had money, he had power, he had privilege. He had their careers, their livelihood, their dreams in the palm of their hand. And while people say this person was there for the money and that person was there for the money, that person was there for their career. Cassie was there originally for a record deal. She signed a 10-album record deal and never released an album. In fact, she herself said she slowly went from being an artist to a sex slave because she was doing freak offs damn near weekly for multiple times a day, multiple days out the week. What was dangled over her head? Her music career, her dream. She wanted to be a model. She was modeling. This is a man that had ties into different portions of entertainment, music, and modeling. Yes. This is somebody who could blackball you, as he did to Capricorn Clark, who in her victim impact statement spoke about how now she's not even working in the position that she was working in before. She's basically an everyday average mom. You don't get to leave Diddy and be all right. That's why a lot of people were kissing his behind while they were on that stage, like George Kaplan, and said he was his idol. Because he still understood, even decades later, that he still has to stroke the ego of the beast, even though he's sitting in trial testifying against him, subpoenaed to come into court. So he'll lean on the fact that he was forced to come in. And every person who took the stand, you want to know what I observed? As a survivor, I saw that there was still a twinge of control there. And what do I mean by a twinge of control? I mean, they still feared him to a degree. This was the first time many of them have ever spoken out and told their story. And they had to do it in court. And they had to do it under the glare of him sitting there looking at them, tapping his hands, moving in his seat, passing the notes. And the notes that he was passing, when certain questions would get asked, you could see that it was like a jab to that person. If those 65 letters that were written for him after his conviction don't show you that he is still tied in, I don't know what else will. Because in the whole 2 months, the 7 weeks of that trial, that's what we didn't see. I said this yesterday. We didn't see 65 people showing up to court to support. We didn't see that. We didn't see Carisha come down to the court with her free poppy sign. We didn't see these executives and these other moguls and heads of corporations. We didn't see all these prestigious people coming down to the courtroom in support of. And I get it. It probably doesn't look good for them. But you might as well have come down to the court because your support letter is a public record now. So we know who you are. We see how you view them. Chef Jordan wanted to be a chef. She ends up landing a job in her 20s with one of the most powerful men in hip hop. Dream job, her career. Subjected to this work life that's excruciating and it's abusive in its own right. Mia wanted to break into television and entertainment. In her 20s, meets Diddy. That's their dream. He took the dream. He took the dream that they had and crushed it. Made it a nightmare, weaponized it against them. Actually, there was 2 celebrities that showed up. I believe it was G-Dep and Diddy. Audacity me, I don't know you, but okay. You know, this is something that we do if you over here at the bar. But anywho, back to what I was saying. And Mia was attacked and drugged so bad. She was attacked and drugged so bad, that woman said, I'm going to that courthouse and I am going to have one last stare in his face. And I'm going to say what I need to say. And I only need 5 minutes to say what I gotta say. And Diddy is trying to stop her from speaking. He's trying to once again mute her. Let's get this up on the screen, shall we? Now, the government respectfully submits this letter regarding victim statements at sentencing. In addition to the victim impact statements submitted by the government in advance of sentencing, the government understands that the victim who testified under the pseudonym Mia at trial wishes to be heard. Then they go on to say that underneath the Criminal Victims' Rights Act, victims of an offense have a right to be heard in court proceedings, which includes sentencing. Okay? Now, let's get down here and let's read the last part because we're going to get to what his team responded. All right? As noted above, Mia has requested that the court provide her the opportunity to be heard at sentencing. Although Mia is not a statutory victim of the defendant's offenses of conviction, she testified at length at trial about her abuse by the defendant during her employment for him from approximately 2009 through 2017. Mia's counsel has informed the government that if permitted to address the court, her statement will be approximately 5 minutes in length. For the foregoing reasons, the government respectfully requests that the court grants Mia's request to be heard at sentencing. Now, Diddy's team is coming back. They're clapping back and they're saying, hell no, to the no, 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 hell to the no. They don't want Mia to speak out because Mia is not Cassie, Mia is not Jane, and the portions of testimony that she gave, they're saying it doesn't hold any weight or merit here because she's not one of the people who were affected by what he was charged with. So now let's get into what the defense has said about Mia testifying in court. And then I'm going to talk to you about what Mia is doing. Okay. So this comes from the desk of Agnifilo. Okay. And he says, we write in opposition to the government's September 30th, 2025 letter motion requesting that a person with the false name, not pseudonym, false name of Mia speak to Mr. Combs' sentencing for charges of which she is not a statutory victim. Over defense objection, Mia was permitted to come into the courtroom, assume a fake identity, complete with a made-up voice and demeanor. So here we go with them saying that Mia's voice was fake and that her demeanor was fake. But I'm gonna tell you something. When they played the video of Mia and her doing the whole hop in and all of that, she sounded like the same voice to me. The only difference was Mia was quieter. Never once did Mia look up at Diddy. Not one time did she look at him. She looked down the whole time. We read her victim impact statement. Is Beast in here? Did y'all talk him up? I happen to look over and I see something about Beast. Y'all stop blocking Beast. He helps the engagement. Anyway, and lie about a defendant in a criminal case, all behind the shrouds of anonymity. I always struggle with that word. She lied that she had sexual contact with Sean Combs without her consent. She lied that she was a victim. Virtually everything that came out of her mouth was a lie. If you've been following other content creators, this is the narrative that they've been saying, that now the defense is not being so professional or eloquent. Wait, what happened? Bobby Brown, aka moderator, ate shit. Who is Bobby Brown? I know you're not talking about Uniquely, because Uniquely will get you. Please don't disrespect my mods. Okay, we don't play that shit over here, boo. Not your Rocky Road and your baby Ruth. Did you just call him the thing from Goonies, Sherm? I'm not looking over here. Let me get back to these documents. I don't hear any professionalism. I don't hear any of that. What this sounds like to me is a letter like as if I typed it. They straight up and down said that her identity was fake. They called her a liar. Yeah, I could have wrote better than this. Anyway, one of the greatest vagaries of enlightenment that once held sway over part of Europe is trial by jury. And a jury of 12 people that had little difficulty concluding that this person with the false identity, voice, and demeanor was lying, and it acquitted Sean Combs of anything and everything related to her testimony. But she apparently is not done. Now that the jury is gone and her lies will be tested by cross-examination, or will not be tested by cross-examination or evaluation by a fact finder, she wants to return to court, still beneath the shrouds of anonymity, to lie again. Simply, she is not a victim of anything. She had adult consensual sex contact with Sean Combs on a handful of occasions, and as her many writings show, held him in the highest regard for years afterwards. How do we know this? The same way the jury did, because her testimony was blatantly incredible in every way, as was the testimony of so many of the government's witnesses. Moreover, that she is so eager to return to court, which she plainly does not have to, and is not even entitled to, puts her proffered fear of testifying at trial into clear relief. This was a show for her. She got to lie. She got to testify with a false identity. She got to try out her fake voice for the jury of savvy New Yorkers. But she also saw the consequences of lying to a jury. They don't believe you. So Now that the jurors have returned to their lives and she could testify without scrutiny, she wants to come back, still under a fake name, still with the false narrative, to further sully this proceeding. Thank you for your consideration. He don't say because of all of these things we oppose. No, none of that. It sounds to me, listen, remember what I was saying to y'all just a little minute ago about how that sounds to me, that doesn't sound like a lawyer talking. Chat, 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 chat. Y'all let me know in the comments. Did that sound like a lawyer to you that was talking? I have never heard lawyers come out and be like, she had a fake name, a fake voice, a fake persona. She lied. She's a liar. And because she's a liar and lied, and she lied so much and lied. I know we down to the wire, but decorum is still required. And basically, yes, I agree, very unprofessional. And based off of what they're saying about Mia, they're telling everybody that everybody lied. Everybody lied except Diddy. Let me ask y'all this. At what point in time have you seen even the slightest twinge of remorse come from Diddy? Has Diddy seemed remorseful for anything that he did at all? Uniquely. I can't even look at my comments. Phanasia, thank you. Phanasia said not one time. Nothing that Diddy has done has shown any remorse for anything. Gold Digger says, nope, right. Fake this, fake that. Why is he using that type of language? Exactly. Brooklyn 514 underscore NYC says, nope. And that's the problem. That's the problem. That's the problem. Uniquely said not even a speck. Okay. Swagger says, Diddy don't care. He feel like he's gonna run the city again. There has been not one even speck of dust that he's remorseful. Because like the government pointed out, like I pointed out before, even with the whole Cassie thing, when her lawsuit came out, he denied everything. He denied everything and then settled that case within 24 hours of its filing. Then he continued to deny any wrongdoing until the video came out. And then we heard in court under testimony from Jane, that whole apology was strategized. And it still didn't work. Tanya says, LOL, sorry, Henny, we're talking about everything under the sun. I know. AP, I don't know what you're saying. Is Sissy only worried about a what? He over there throwing a 2-year-old tantrum. That part. Sunday Dollar says, I would think an attorney would use the word fictitious, not fake. Thank you, Sunday. This is what I'm saying. AP says, Diddy only worried about his behind. Exactly. Phanasia says, and that's why he needs to sit, make an example to these celebs. All right. Queen Grandma Rocks, how are you? She said, sounds like a slip taker. Sherm said, they better not let Diddy out at this state of mind he probably in. That part. This is what I'm saying. Okay? This is what I'm saying. All right. Now, we already read this. Yeah, we already read about Mia. We already read their denial of Mia. What is this? What is this? This is the judge. Yep, that's the trial. We've already read that. Because I have other documents. Okay. Now, what is this? Nope, that's old. We already covered that. All right. So moving right along. Okay. So now, here's where it gets messy. Okay. Because what I have for you guys is the government's response to the defense. Baby, they are kung fu fighting. And I love when this happened. All right. So let's zoom in a little bit and let's get into what Jay Clayton had to say. Now, y'all remember Jay Clayton is actually Trump. Okay. That's Trump's homeboy. That's Trump's homeboy. Okay. So now he comes back and he says, let's get into it. The government respectfully submits this letter in response to the defendant's opposition to Mia's request to speak at sentencing. The defendant's letter, which notably lacks a single legal citation, is offensive, unprofessionalism, and on its face, nothing more than a blatant attempt to smear a victim who bravely testified about years of traumatic events she experienced at the defendant's hands. Baby, clap back. W clap back in the chat. W clap back in the chat. This is what we're now. I'm gonna tell y'all right now. I did not read this. Okay, I didn't read this. Okay. I'm reading it for the first time with y'all right now. So y'all are getting ThatGirlHenny's review. Raw. And in color, okay? W clap back, okay? This is what I'm saying. Clap back. Let's read that one more again, shall we? The government respectfully submits this letter in response to the defendant's opposition to Mia's request to speak at sentencing. The defendant's letter, which notably lacks a single legal citation, is offensive, unprofessionalism, and on its face, nothing more than a blatant attempt to smear a victim who bravely testified about years of traumatic events she experienced at the defendant's hands. This rhetoric has no place in this court or during this civilized proceeding. The court should reject it entirely. Baby! Iridescent unicorn farts, what's popping? Okay, W clap back. You hear me? This is what we said. Jay Clayton came out. All right. He goes on to say, Mia took the stand in this trial to testify for days about the defendant's treatment of her and those in his orbit. She was clear that testifying was something that she did not want to do. In fact, she had planned to quote unquote die with the truth or what the defendant had done, which is true. She said that. She got nothing out of testifying, no money, no fame, yet she did it anyway because it was the right thing to do. How difficult this experience was for her to appear based on her demeanor in the courtroom, in which she often looked down and struggled to get words out, which is true. That is not how someone lies. It is how someone speaks about the worst thing they've ever had to talk about in their life. To suggest otherwise is offensive. Despite days of lengthy talk hold on, sorry y'all, I lost my place. I got excited. Despite days of lengthy often bullying cross-examination, in which defense counsel explicitly accused her of lying, Mia was ever clear. I have never lied in this courtroom and never will lie in this courtroom. Everything I've said is true. Despite defense counsel's assertions, nothing in the jury's verdict expresses a view as to Mia's credibility. Which is true. They did not say Mia was a liar. That was YouTubers. The jury was not asked to make any findings as to Mia's credibility regarding particular instances of the defendant's violence or abusive treatment of her or others. We cannot speculate as to why the jury acquitted on the RICO count. But as defense counsel well knows, the jury could have believed every single thing Mia said about the defendant's violence towards her and others, some of which was corroborated by other testimony and evidence in the case, and still have acquitted for other reasons, such as a finding that the enterprise was not proven beyond a reasonable doubt, to draw reasons such as a finding that the enterprise, to draw any factual in reference about Mia's credibility based on the jury's acquittal is not only wrong, but it is not allowed under law. Now his lawyers are breaking the law because they sitting out here listening to some of these YouTubers out here. Now, let's see. He goes on to cite a case, okay? And he cites U.S. versus Martinez. Holding court erred when it concluded at sentencing that the jury had necessarily rejected the victim's testimony, explaining that a jury's acquittal on certain counts cannot serve as the independent basis for any factual in references, much less by a preponderance of the evidence upon which the court may base its sentencing. Okay? He goes on to say, Mia was brave to testify at trial, and even more brave to be willing to speak the truth at sentencing after the verdict. She was by far not the only employee, friend, or person who testified as to the defendant's violence, vindictiveness, and cruelty, nor is she the only one who has sought to come forward in connection with sentencing to do the same. The defense's fear of one victim speaks for less than 5 minutes. The defense's fear of one victim speaking for less than 5 minutes volumes as to what it believes may be the impact of her telling the truth. Thankfully, the decision about whether a victim can speak at sentencing or not is not left to her abuser, whose every incentive is to silence her, but to the honorable court. Respectfully submitted, Jay Clayton, United States Attorney. 8 down. He ate down. I like when he eat down like this. Baby, he ate them down for that one. And the reason why I'm saying this is because at the end of the day, attacking victims is never okay. And if you've gone through the victim impact statements and you've listened to what everyone has said, those victims, because that's what they are considered in a court of law that came forward and testified, the victims and the witnesses that have come forward and testified, they all spoke to their disappointment in the jury and how the jury got it wrong. I was in Gene Deal's live earlier today. Shout out to Gene. I was in Gene Deal's live earlier, and Gene Deal was talking about the same thing that I had been talking about, how the government did not put on the best case that they could have, that there was evidence that they did not use to build their case, that they dropped the ball, and that I really don't feel like they wanted him. Because if the government wanted him, maybe they would have thrown everything, including the kitchen sink, the bath water with the baby in it, and all of that at him, and they'd have thrown it all against the wall. There was evidence in this case that they could have brought charges against him for. But make no mistake about it, just because they didn't use all of their evidence in court, don't think that they may not be possibly holding some in the key to spin the block and come back later. And I'm going to tell you something. This behavior that I just displayed, that I told you has been displayed, that just came out loud and clear as day in that letter. His lawyers have been his mouthpiece. If Diddy is citing the Black's Law Dictionary, That means that Diddy has been in his case law. That means that Diddy has been working with his lawyers and giving them what it is that he wants them to say, what motions he wants them to file. He's been definitely working them like employees because guess what? They are employees because they are hired help to Diddy. You think Diddy really respects these lawyers as equals? He don't. They're what is it? Expendable, dispensable. He can get rid of them and hire somebody else. I guarantee you, had they lost this case, this would be a whole nother. I bet you he'd have came with a whole nother set of attorneys. He tells them what to do because he's paying them. They're his employees. And I'm going to tell you something. I love Nicole Westmoreland in the YSL trial. As an attorney, I think she is a pit bull in a skirt. She is a lethal weapon. I loved watching her do her thing. It was just sad to see her go after other victims the way that she did, even though that was her job. Nicole Westmoreland is a victim herself. She's a survivor. And to hear her say how Diddy's demeanor has been with her and how she believes that he's changed, girl. He can put on an act. 7 weeks is nothing to somebody who would spend years grooming people and gaslighting them, taking them through the Prince Charming phase and all of that. Just saying. I'm just saying. Let me make sure that I have given y'all all that I need to give y'all. When it comes down to this Diddy stuff, I said the night before verdict. The night before the verdict. Now, let me tell you what's going on in Diddy's mind right now. He's preparing himself for his final performance in this court. He's been going over his speech, pacing back and forth in that cell, probably. This is just my imagination. Everything that I'm saying is allegedly. I don't really know. Everything that everyone has said against him, he has a mental motive of. Everything that his lawyers have advised him on, every move he's made in business, he's always negotiating. And so he's coming up with the best negotiation that he can because he's getting ready to put on the final act of this piece. And so he's making sure that his delivery is precise, that his demeanor is on cue. He's got his outfit already together. He's already told people what he wants to wear within the guidelines of what he's allowed to wear. And he's going to sit with his attorneys probably tomorrow, either via the phone or a video call or in person. And they're going to go over it. He's going to rehearse his lines just like he did in The Raisin in the Sun. And if this letter that his lawyer has put out there is a preview into what we're going to get from him, he's really going to go in. But I think Diddy is going to do everything and anything to try to appear to throw himself at the mercy of the courts. Now, he's going to bring up the fact, his lawyer is going to bring up the fact that he has completed some courses that should help him. That he's now the model citizen. But, sir, it's only been 3 months. Remember that. It's only been 3 months. It hasn't even been 6. But they say he's changed. Now, I'm all for change. I believe in people, you know, coming out better on the other side. I don't believe in people overpaying their debts to society. I don't believe in that. But I don't believe in being gaslit into believing that somebody has rehabilitated in 3 months. Now, Judge Submarinian is going to do what Judge Submarinian is going to do. And there are people that are saying that he can't go outside the sentencing guidelines and saying what the judge can and can't use. But the judge can most definitely go outside of those sentencing guidelines, because those are merely a suggestion. That was changed a couple years ago, that the guidelines are no longer mandatory, but that they are a suggestion. And for people saying that they can't use anything in this case, they can't talk about the violence, they absolutely can talk about the history of violence, especially being that it ties into this case. If you listen to the government, you hear exactly what it is that they are going to be using in their statements, that they're getting to talk to the judge or say anything to the judge during this sentencing period, giving closing arguments or whatever they're called. They're going to bring up the preponderance of violence that we've heard about over the decades, the violence. The fact that Cassie was leaving a freak off and trying to go home, and it resulted to violence, that brings the violence in to the Mann Act. Because the escort that was sitting in the room, yeah, he was transported there for the purposes of prostitution. And then there's Jane. And Jane got punched in the face and slapped up and chased out the house and all of that. Her doors kicked in. And then she was made to clean up because she wasn't going to fuck up his night. Where he then brought somebody in to have a freak off. Where somebody was brought in to engage in prostitution. Violence. The preponderance of violence is brought in through that. Because there was drug use during these freak offs, where the people were moved around and transported to engage in the acts of prostitution, because there were drugs involved, drug usage will definitely come up. And it can. And it can weigh heavy on this sentencing. And let's not forget his PSR suggested 7.5 years. And the government suggests 11. I say 5. Now, if I'm wrong, no problems with coming and saying that I'm wrong. But if I'm right, don't make no excuses. Don't say they cheated him. Because if we're going to keep it all the way real and a buck and a bean right now, he didn't win anything. He beat RICO charges, but he ain't free. And if you think that the judge is not going to talk about the behaviors that have been displayed by him since the verdict from the jury, if you think the judge is not watching and analyzing and weighing everything out, you're sadly mistaken. I wish I was going to be there on Friday. But that's okay. Because Mama Flip is going to be there. And we're going to have her do some reporting for us to tell us what goes down in that courtroom, if she agrees to. And I don't see Diddy walking out that courtroom tomorrow. because nothing about anything has said that he's gotten the proper help that he needs. And I think that by not making sure that this man is getting proper help and doesn't learn consequences to action is doing him a grave disservice. Free Diddy when Diddy is ready to be freed, and then free him to heal him, not free him because it's something that's socially acceptable. And stop using that black man down thing, because I'd be saying the same thing if it was somebody of another ethnicity. You better go watch my Alexander Brothers videos, because I've been talking about them, excuse me. And I still locked them under the jail because of the stuff that they do. So I'm actually a little harsher. But anyway, if you're here on the YouTube, thank you for tapping in and tuning in with us. Uniquely, can you drop the link for the Twitch? Because we're going to be heading over to Twitch. Okay, we're going to be ending the stream. But I had to come on here and I had to give you guys that information because I couldn't just skip over it. And of course, I'm going to be here to report for y'all on Friday. I'm going to make sure I give me a good night's rest so that we are up bright-eyed and bushy-tailed on Friday. So we could be here. The court starts on Friday. Yeah. Yeah. Hold on, I'm going to see if I can get it because Uniquely must have stepped away for a second. So let me see if I can pull. Oh, there it is. Sorry, I thought you walked away for a second, Bookie. All right, so we are going to be heading over to the Twitch, and we're going to talk about Nicki Minaj. Okay, we're going to talk about Nicki Minaj and Cardi B. I'm going to drop the link. You guys can come up and y'all can, hit the panel if y'all want to. We're going to talk maybe a little bit about Sean and some things that are going on over there, and then we're going to talk about this government shutdown. Okay, we're going to talk about the government shutdown because this is affecting all of us. All of us. Okay, so head on over to the Twitch bar by clicking that link. All right. Yes, Twitch bar, not sidebar, but Twitch bar. Not you gonna be at the water table on Friday. You already anticipating being at the water table? Come on now, swagger. All right, you guys. We're going to say thank you for tapping in and tuning in with us for the late night pour up here on YouTube. But we're going to say good night to you on YouTube as we continue on over on Twitch.